We'll move to the next speaker, Ms.Devyani Srivastava ji. Devyani ji is there?
Yes, sir.
Oh, thank you, Devyani. Devyani is a head for the police reforms program at CHRI, Commonwealth Human Rights Initiative, which is an NGO which exclusively works on access to justice, police and prison reforms. Now, she is also working on the project on mainstreaming of women in the policing. She has been earlier involved with the crime victimization service and police response to the caste-based atrocities. CHRI basically deals with the research, advocacy, and structural reforms in the police, which includes police accountability. So I would request Devyani to emphasize and describe some of the studies which she has undertaken regarding the compliance or non-compliance to the Section 41, Amended 41. Thank you, Devyani. Please go ahead.
Okay, good morning to everyone. On behalf of CHRI, let me begin by thanking IPF for inviting us for this discussion and giving us the opportunity to share our findings on arrest procedures. Now, we've been sort of trying to understand the compliance and implementation of these amendments, particularly since 2014, once Anesh Kumar judgment was delivered. And today in my presentation, what I want to do is just quickly share some of the findings in terms of the standards and templates that have been developed by state police to help in the implementation of these provisions. The idea is to really understand whether enough guidance is being given to Thana level officers, to IOs, to be able to implement these. So there are three things that we've looked at. Most recently, we've looked at the issue of checklists that have been developed. So Barkat ji has explained already what that means. So we asked information through right to information, from all state police headquarters to share copies of checklists that they have developed. That's one. The second is on the issue of arrest memos. Again, we looked at the formats of arrest memos that are being used. Of course, we try to review some of the arrest memos that we got hold of. And finally, 41C, which is basically disclosing arrest information. So starting with the issue of checklist.
Discussion time, sir. And remaining, I will try to cover some during the course. Yes.
So we were able to get a hold of circulars issued in 16 states. And please bear in mind that this is all RTI related research. So our findings are subject to what was shared with us. So we looked at the circulars. Now, what we found is in most states, basically the provisions of the law, the Section 41 conditions were circulated. The judgment is circulated and the provision is circulated verbatim as saying that now this needs to be followed in carrying out arrests. Now, there were some exceptions to this, and that's what I wanted to highlight here. These are, a sort of a template, standard template of checklists, that most states have developed. So if you look at Odisha, there's the basic information, and then you have those 5 or 6 conditions that 41 itself specifies. That's basically the checklist. Again, this is from Gujarat, similar, language and similar sections. In Gujarat, one notices that the form itself is titled as not just arrest or checklist for arrest or reasons for arrest, but actually reasons for remand also, because as has been explained, if you're arresting someone, then you have enough grounds to seek remand also. So that is from Gujarat. Now in Delhi, it's interesting that the checklist that they shared with us and that seems to be being followed is very elaborate, and they've gone much beyond 41 conditions. And some of the language that, if we read some of the language, then the sense that one gets is that actually, the conditions that have been added are broad enough to justify any and every arrest. So for example, number 5, whether the accused is having permanent residence in Delhi becomes a reason for justifying arrest. And number 6 is related to address verification. Now here, conditions such as whether the accused, number 10, whether the accused is required for custodial interrogation to unearth the case, is mentioned as one of the conditions to justify. And then others are similar to what Section 41 says. Then, there are 18 such conditions that Delhi has developed. whether the presence of the accused cannot be ensured at the time of requirement. It's a fairly broad, language that doesn't sort of tell us anything really, or doesn't give IO enough of an instruction to follow. So that is one issue that is emerging. So this was an example where conditions have been very broad. Another example is from Himachal Pradesh. Now here the checklist language is a bit more specific. It's more narrowly defined, which will help, actually an IO to understand whether this becomes the reason. So beyond the 5 or 6, which section 41 says, the additional conditions that they've laid down are, things like the facts of the case have been collected and verified to believe that she has committed the offense. Number 8, being previously found to be involved in similar offenses, etc., etc. So these appear to be more specific to help someone decide whether arrest is needed. Now, in the case of Himachal Pradesh, what was interesting is that it stands out as the only state from where we received information which has also developed a checklist for non-arrest. Now, that was an important sort of condition, amendment in that was brought into law, where the reasons for not arresting someone also have to be recorded and submitted before the magistrate. And I think both, if read together, gives sufficient guidance to see whether arrest is to be made or not, because these conditions, say that you don't have enough material facts to carry out an arrest, or prima facie the offense appears to have been committed by the accused, yet his chances of committing further offense could not be concluded. So these, is language that we think is helpful and could be elaborated upon based on on experiences from the ground. She has of course been served 41A notice, so therefore arrest is not necessary at this stage. So this was an important example that I wanted to highlight. Then 41A has also sort of Barkaji has explained quite a lot of 41A. I just wanted to highlight the judgment of Delhi High Court, which actually lays down some procedure for 41A to be implemented. The Delhi High Court has provided a model form of the notice of appearance to be served, as well as an acknowledgement form. So if an appearance is made, then the IO is supposed to acknowledge and give a signed form to the accused. It also recognizes that the accused may seek an alternative time from the date that he or she has been asked to appear before the police. Then, some more procedures in terms of record keeping. So the IO has to maintain a copy, the SHO has to maintain a booklet, just things like that, which will strengthen the supervision, as has been pointed out, of the implementation of these provisions. Now, from the documents that we received, Nagaland is the only state that has adopted these guidelines in entirety. So not just the model form of appearance and the acknowledgement form, but the other provisions have also been adopted, through their circulars. Most other states, example Telangana, I just wanted to show this form. This is the form of appearance and the acknowledgement, forms that the court laid down. Most states have basically adopted these forms and not the other conditions that the Delhi High Court laid down. That's on 41A. Some of the case law has already been mentioned, so I'm not going to repeat, but one thing that stood out, the one sort of important order from the Supreme Court in the case of Rohini Biswas, a recent order has made some important observations on 41A. I'm not going to explain the case, but just want to share what the observations were. One is that the petition seeking quashing of FIR under 482 is not sufficient in itself to obviate compliance with the 41A summons. So just because the petitioner has filed, is seeking a quashing of FIR, will not stop or does not prevent the police from seeking, obviously, issuing a notice. The other thing is important to ensure that the power under 41A is not used to intimidate, threaten, and harass. Now, this was a very specific case because this was a case where the lady was, one person based in Delhi was charged for an offense, for basically questioning the government of West Bengal's handling of lockdown conditions. So it was based on Facebook posts that the person had made. So the Supreme Court, when this sort of went to the Supreme Court, it made the observation that in this particular case, the police cannot compel the lady to travel to Calcutta and appear before the police station that had issued 41A notice. and that, the cooperation through email or video conferencing should be enough. And that they made the observation that the objective is not to intimidate, people who are willing to cooperate. So that, is a useful thing to remember. Then basically, so just looking at the checklist, what we find, just looking at the standards and templates, is that, a lot more operational guidance, will be helpful, like Abaji has also sort of pointed out. Some sort of standard formats, at least within each state, to be followed, procedural guidance, way of supervision and review, training, of course, and accountability. And I think, on anything that is reduced to a checklist exercise always has, runs the risk of becoming mechanical. And this sort of function of policing is something where judgment is needed, some amount of discretion is needed. So the approach of implementing checklists, to our mind, should really be balancing that discretion with accountability. So, police officers and IOs must see it as something that will help in their exercise of powers rather than curtail it. Now, I recognize that's not how it is seen, but that would be a useful way to approach it. That was on the checklist. The other study that we had carried out, this was some time back in 2016, where we sought to review for the arrest memos that have to be produced, that have to be prepared at the time of arrest. And what we found is, I'll just come back to the case law, but again, the objective was—
Devyani, please conclude in 2 more minutes, please.
Yes, sir. So again, what we sought to review is what kind of guidance has been issued in preparing arrest memos. And then our study, we were able to review 53 arrest memos from Rajasthan and 23 from West Bengal. But unfortunately, although our attempt was to get hold of arrest memos both from the police station and the corresponding court, that sort of alignment we were not able to do. But what we found, 2 or 3 important points. I mean, these studies are there on our website, so I'll urge everyone to sort of take a look at them. But there was confusion regarding record keeping. So once an arrest memo is prepared and is shared with the magistrate at the time of first production, the police response to our request for these copies is that we don't have a copy of it. It is submitted to the magistrate. It's with them. The magistrate's versions were, that after first production, we send it back to the police. And it becomes part of judicial record really only at the submission of final report or the charge sheet. That's when it becomes part of judicial record. So I think there is confusion about where and who should really be the custodian of reviewing arrest memo. That's one. Of course, formats, etc., lack of consistency. Those are some common concerns that were emerging. In terms of the information that is entered in arrest memos, again, place and location is not specified, although that is a crucial function of arrest memo, and that sort of indicates that it is not being prepared at the place of arrest, but really when it is, when the person is brought to a police station. The independent witness signature. So the signature can be either the relative of the person who is being arrested or an independent witness, from the vicinity. So signatures are included, but it is not specified whose signature it is. So therefore it's unclear. And it's also, there is an issue. So police officers shared with us that obviously there's an issue of public coming forward to sign something like this at the time of arrest. And so therefore the practice of police officers themselves becoming witnesses to arrest, is quite common, which defeats the purpose of that independent check. Now, some of the arrest, memo formats that were shared included a lot more features than what the law says. And some of it is worth, looking at and reviewing. It includes the date and time of first production. It includes listing of injuries, the signature of magistrate at the time of production. So these are formats that can be looked at and seen whether they can, be improved. Sorry. Yeah. Then finally on 41C, also similar findings. We tried to understand not by actually physically going to the control room, but starting at least with the websites to see what kind of arrest information is available. This is as of early 2021. And what we find is about 13 states do provide some information on arrestees on their websites, on their web pages, and then the remaining is unclear. the circulars that we were able to get again on implementation of 41C specifically, 2 states stand out, Kerala and Bihar, who seem to have issued detailed instructions on how that information has to be prepared and made available both in the control room and on their websites. These are the steps that they've laid down. It lays down a command system. It lays down what kind of information has to be disclosed. So this is the kind of sort of targeted guidance that one is looking at in order to implement these amendments in law. Again, all of this is there on our report, so I'll be happy to share those copies. I'll stop here. Thank you, sir.
Thank you, Devyani. I think a very detailed study on the way the amended sections are being followed by the various police forces. One can also find a lot of variation in the arrest memos or the checklists from state to state. So I think Ramchandran sir, for IPF, maybe along with CHRI, there could be a task to standardize these performers. If we can standardize the national level performers and convert to all the states, maybe because the CRPC is same, it should help. She also spoke about balance between the police discretion and accountability. So that of course goes without saying, and need for training wherever the gray areas are there. Little alarming, only 13 states websites are disclosing the information about the arrestees. So Devyani, I hope that you have covered all 37 or 38, or you only looked into how many states?
No, so the attempt was to review all state police websites. And then, I don't want to go into detail of what we found. Some places you can't go beyond the homepage because you need to register and things like that. So, yeah. So
Devyani, I will be happy if you can share these studies with the IPF. They would be very useful, and we can see what could be the further areas for work. So once again, thank you very much.